If you or someone in your family is currently waiting for a green card, whether as the spouse of a permanent resident, through an employment-based petition, or through the asylum process, then the information I am about to share with you today could have a meaningful impact on your timeline. April 2026 has introduced some of the most favorable filing conditions we have seen in a long time for several key immigration categories. F2A is current, EB2 has seen forward movement, and the dates for filing chart is open for both family-sponsored and employment-based categories this month. At the same time, there are significant proposed regulatory changes on the table right now that could affect asylum applicants in a serious way, and the deadline to submit public comments is approaching fast. I encourage you to stay with me through this entire video because much of this information is time-sensitive, and staying informed right now could genuinely benefit you and your loved ones. I'm going to walk through all of this step by step so that you have a clear understanding of where things stand. As of today, April 8th, 2026. Let me begin by explaining what the Visa Bulletin is, because if you are relatively new to the immigration process, this is one of the most critical monthly documents you should be aware of. Each month, the United States Department of State publishes a document known as the Visa Bulletin. This publication informs immigrants and their legal representatives which categories of green card applicants are eligible to move forward with their filings based on what is called a priority date. Your priority date is typically the date when your employer or sponsoring family member initially submitted a petition on your behalf with USCIS. You can think of it as your position in line. The Visa Bulletin tells you whether your position has reached the front or how far back you still are. Each month, those dates may advance, remain unchanged, or in some cases even move backward. That is why immigration professionals monitor this document very closely every single month. Now here's what makes April 2026 especially noteworthy. For both family-sponsored and employment-based preference filings, USCIS has confirmed that applicants should refer to the dates for filing chart from the Department of State Visa Bulletin for April 2026. This is a critically important detail. Every visa bulletin contains two separate charts. The first is the final action dates chart, and the second is the dates for filing chart. The final action dates chart indicates when your green card can actually be approved and issued. The dates for filing chart, which tends to be more generous, tells you when you are eligible to submit your adjustment of status application, secure your position in line, and begin accessing important benefits such as work authorization and travel permission while you wait for final approval. When USCIS authorizes the use of the dates for filing chart, it opens the door for a larger number of people to take action right now, even if their final green card approval may still be months or even years away. This marks the sixth consecutive month that foreign nationals in both family and employment-based categories have been permitted to use the dates for filing chart to submit an adjustment of status application. That is an unusually extended stretch, and it has provided many applicants with a meaningful advantage in their overall timelines. Let us start with the F2A category, because this is where the developments are perhaps the most encouraging for families right now. The F2A category applies to spouses and unmarried children under the age of 21 of lawful permanent residents, meaning green card holders. If you hold a green card and your spouse or young children are waiting to permanently join you in the United States, this category directly impacts your family. The most notable shift in April 2026 occurred in the F2A category, which has returned to current across all countries. This is a significant development for spouses and minor children of green card holders. When a category is listed as current, it means there is no backlog based on your priority date. Anyone who is otherwise eligible may file immediately, regardless of when their petition was originally submitted. This does not happen every month, and families should pay careful attention to this window. The April 2026 Visa Bulletin from the State Department lists the F2A category as current for filing purposes. This is a meaningful shift that may allow many families to move forward with gathering documents and, where USCIS permits, submitting adjustment-related filings without waiting for a specific cutoff date. However, and this is an important distinction, being current on the dates for filing chart does not mean your green card will be approved right away. Final action dates for F2A are still not fully current for April. For most countries, the final action date sits at February 1st, 2024, while for Mexico it is at February 1st, 2023. In simple terms, this means you may be able to file your adjustment of status application now and begin receiving the benefits that come with having a pending application, but your final green card approval will still depend on where the final action dates stand when your case reaches the front of the line. Filing now is still a valuable step because it secures your position and provides access to work and travel documents in the meantime. For F2A applicants, being in a position to file now represents a considerable advantage. That said, despite forward movement, visa backlogs remain a reality, and applicants from countries with high demand, particularly in oversubscribed categories, may still experience slower overall progress. So if you are the spouse or child of a green card holder, I strongly encourage you to speak with a qualified immigration attorney or accredited representative this week. Ask whether now is the appropriate time to file your I-485 adjustment of status application. Begin gathering your documents. Confirm your priority date. And do not assume this filing window will stay open indefinitely. Visa bulletin dates can shift forward or backward from month to month, and what is current today may not be current next month. Now let us turn to the employment-based categories. The employment-based categories also showed notable improvements in April 2026. EB2 and EB3 for the rest of the world advanced considerably, with some categories becoming current. The EB4 category has also recovered from being unavailable in 2025 to being active again in 2026. For those who may not be familiar, EB2 refers to the employment-based second preference, which generally covers professionals holding advanced degrees and individuals with exceptional ability. EB3 covers skilled workers and professionals. These categories affect hundreds of thousands of individuals who came to the United States to work and are now seeking to make their stay permanent. For EB1 and EB2 applicants, the April Visa Bulletin brings encouraging signs. Many applicants may now find themselves eligible to file for adjustment of status or move closer to receiving a green card this month. One important piece of context to understand is why these dates have advanced so significantly. One perspective among immigration attorneys is that certain policy developments affecting immigrant visa issuance for nationals of specific countries may have created a surplus of available immigrant visas. Because USCIS must project supply and demand into the future when deciding which chart to authorize, this may have given the agency enough confidence to keep the more favorable dates for filing chart open for a longer period than is typical. This is important context because it suggests that current favorable conditions may be tied to circumstances that could change. The wisest approach is to take advantage of this window now rather than waiting to see whether it continues. If you are in the EB2 India category, you are likely well aware that the backlog for Indian nationals in employment-based categories is among the longest in the entire immigration system due to per-country limits established by Congress. EB2 India showed slight forward movement in April 2026, which is welcome progress, even though the overall backlog for Indian nationals remains substantial. Every month of forward movement matters when you are facing a multi-year wait. Staying engaged with the Visa Bulletin, working with a qualified attorney, and ensuring your underlying I-140 petition is properly maintained are the most important steps you can take in the meantime. Now, I want to shift to a topic that carries a different kind of urgency, and that is the situation currently facing asylum applicants. If you have a pending asylum case or if you are considering applying for asylum, there is a proposed rule change you absolutely need to be aware of right now because the public comment deadline is approaching soon. On February 23, 2026, the Department of Homeland Security published a proposed rule in the Federal Register titled Employment Authorization Reform for Asylum Applicants. This proposed rule would substantially alter how and when asylum applicants can obtain employment authorization documents, commonly referred to as work permits or EADs. Here's what the proposal says in straightforward terms. Under the current federal regulations, asylum applicants are eligible to file for a work permit after their asylum application has been pending for 150 days, and they can receive it no sooner than 180 days after filing. If this proposed regulation is finalized, asylum applicants would be required to wait 365 days, a full calendar year, after USCIS receives a complete asylum application before they would become eligible to apply for an initial EAD. That would effectively double the current waiting period that many applicants depend on. This represents a profound change for individuals and families who rely on the ability to work legally while their asylum case is being processed. But the proposed changes extend beyond just the waiting period. The proposed rule also includes a mechanism that would allow USCIS to pause the acceptance of initial EAD applications when the average processing time for affirmative asylum applications exceeds 180 days. Additionally, the proposal would extend the agency's adjudication timeframe for those EAD applications from 30 days to 180 days. What this means in practical terms is that even if you reach the 365-day mark, a processing backlog could trigger a pause that prevents you from even submitting your EAD application. Current processing times for asylum applications are considerably greater than 180 days, and based on the preamble to the proposed rule, USCIS anticipates that, if implemented, new EAD applications for pending asylum applicants could be paused for an extended period, potentially spanning many years. It is important to emphasize that this is a proposed rule, not a final rule. It has not taken effect. The public comment period remains open through April 24, 2026, and a final rule cannot be published until after that date. The rulemaking process, including the possibility of legal challenges, means that actual implementation could take additional time. However, the direction being signaled is clear, and asylum applicants should consider acting with urgency under the current rules while they remain in place. If you have reached the 150-day mark on your asylum application and have not yet filed your Form I-765 for an EAD, you should speak with an immigration attorney as soon as possible. Filing under the current rules before any final rule takes effect places you in the strongest possible position. If you already hold an EAD and it is set to expire within the next 6 months, consider filing your renewal promptly. Under current rules, a timely filed EAD renewal receives an automatic extension while the renewal application is being processed, which helps prevent gaps in your work authorization. The proposed rule is widely expected to face legal challenges. Historically, changes to asylum work authorization rules have been the subject of litigation, and even if a final rule is published, its implementation may be influenced by lawsuits, injunctions, and court rulings. That is something worth keeping in mind, but it is not something you should rely on to protect your individual situation. The most proactive step you can take right now is to consult with a qualified immigration attorney about your specific case and timeline. Let me now provide a clear set of practical steps based on everything we have discussed today. If you are in the F2A category, meaning you are the spouse or unmarried minor child of a lawful permanent resident, check the April 2026 visa bulletin right now at travel.state.gov. Confirm that F2A is listed as current on the dates for filing chart. Begin gathering your documents, including your I-130 approval notice, your passport, your civil documents, your medical examination results, and your financial support documents. Then consult with an attorney or accredited representative about whether you are ready to submit your I-480 adjustment of status application. Do not delay, because these filing windows are not guaranteed to remain open. If you are in an employment-based category such as EB1, EB2, or EB3, visit the USCIS Adjustment of Status Filing Charts page and compare your priority date to the dates for filing chart for April 2026. If your priority date is earlier than the date listed for your category and country of birth, you may be eligible to file now. Work with your employer's immigration counsel or your own attorney to prepare your I-485 package. If you do not yet have an approved I-140 petition, that is the essential first step. Speak with your employer's human resources team or a qualified attorney about initiating that process. If you have a pending asylum case and have not yet received an EAD, track your 150-day clock carefully using the USCIS case status tool available online at uscis.gov. Once you reach the 150-day mark, prepare your Form I-765 and file it without delay. Do not wait until day 180. The sooner you file after day 150, the better your position. If you are already in the process of renewing your EAD, make sure to file before your current document expires so that your automatic extension protection remains intact. For everyone watching, I also want to acknowledge the broader context of this moment. The immigration landscape in 2026 is one of the most dynamic and rapidly evolving environments we have seen in years. Processing times are shifting, court decisions are shaping policy direction, proposed rules are being published in the Federal Register, and the Visa Bulletin is moving in ways that create real windows of opportunity. But those windows require action. Waiting and hoping is not a reliable approach right now. Knowing your dates, understanding your category, and maintaining a relationship with a qualified immigration professional are your most powerful tools. I want to be clear about something important, as I always emphasize here at US Updates Hub. Everything I have shared with you today is purely informational. It is based on verified official sources, including the April 2026 Visa Bulletin, published by the Department of State, official USCIS filing guidance, the Federal Register notice published on February 23, 2026 regarding the Asylum EAD proposed rule, and analysis from credible immigration law practitioners. However, this is not legal advice, and it cannot replace the guidance of a licensed immigration attorney or accredited representative who understands the specific details of your individual case. Immigration law is complex. Circumstances vary greatly from person to person, and policies can change, sometimes with very little notice. Always verify current information at uscis.gov and travel.state.gov and consult a professional for guidance tailored to your situation. Here at US Updates Hub, our mission is straightforward. We want to ensure that you, whether you are a green card holder, an asylum applicant, an employment-based immigrant, or a family member somewhere in the system, have access to clear, timely, and accurate information. Knowledge is a powerful asset in the immigration process. And right now, in April 2026, there are real opportunities and real risks that every immigrant family should understand. We will continue bringing you these updates each month as the Visa Bulletin changes, as proposed rules move toward finalization, and as the courts weigh in on policies that affect millions of lives. If this video was helpful to you today, please give it a thumbs up. It genuinely helps us reach more people in the community who need this information right now. Share it with someone in your family or community who might fall into one of these categories and may not yet be aware of these developments. And if you have not yet subscribed to US Updates Hub, please subscribe and turn on your notifications so that you never miss a monthly update. Check the description below for official links to the April 2026 Visa Bulletin, the USCIS adjustment of status filing charts, and the Federal Register notice on the Asylum EAD proposed rule. These are your primary sources, and I encourage you to bookmark them and check them regularly. We are here for you. We will keep showing up with the information you need, delivered clearly, calmly, and without unnecessary alarm. Take care of yourselves and take care of your families. Disclaimer: this content is for educational and informational purposes only. It does not constitute legal advice.